I can give you 9 legalish things that every TigerLabs member, really every entrepreneur, really anyone who's running or in business ought to know. This is like the top legal takeaways I can offer you from my time being a business lawyer. So, who exactly am I again? If we haven't met, I'm Jason Meyer. I started a law firm called Princeton Business Law, and the whole idea of the law firm is to be the lawyer for small and medium-sized businesses, for entrepreneurs and the businesses that they love and that are expressions of themselves or that they invest in. But all for the 97% of the businesses in the country that are not publicly traded huge companies, still have legal issues, still need lawyers. That's what I built the law firm to do. I started it many years ago, and for 7 years I have been, as far as I know, the only business lawyer, resident, and member of TigerLabs, which is the whole idea. I moved the firm here because this is where the entrepreneurs were, and that still works for me. The thing that's different, I think, about the way I practice law and the idea of my law firm is I have literally been in your seats. I was an entrepreneur before I went to law school. I ran a radio station. Over time, at this point, it's like 11 different private companies that I've either founded or run or been in the C-suite of. I spent 13, 15 years not practicing law full time, but instead running companies and organizations full time. And I like to bring that business experience and that operating experience into what I do. And I think you'll hear that as I go through things. Okay, 9 legalish things. Number 1, you come across questions about confidentiality, NDAs, and non-competes. And the question is, how do I protect what matters most to me? Often what matters most to your company are your clients and your customer base, but there are also going to be secrets, trade secrets, the way you code, the way you research. Or flip the script, you're working for someone else, or you're part of some other organization, and they want to make sure you don't leave with their secrets or with their clients. What are the tools that work for that? What's still there? You hear a lot about non-competes, agreements not to compete. That is, when I leave, I cannot work for your competitor. When you leave, you can't work for my competitor. There's a lot of talk about those in the law. The bottom line is they exist. They're real. They are enforceable. There are limits to how much they can be enforced. You can't do it like 3 years, the entire country. They need to be limited in time and space, and they need to be reasonable. And there's some concern over bargaining power. There was a lot of talk about a year ago about non-competes being completely banned, as they are in California, by the way. That died. It died, frankly, before the administration changed. But once the White House changed, that initiative of the FTC completely died. New Jersey's talked about limiting non-competes, never pulled the trigger on it. They are enforceable. That's the bottom line. And by the way, even people who attack them don't attack non-competes if it's related to the sale of a business. So if you have a startup, you sell it, the person you sell it to says, yeah, now I want a non-compete, man, that is completely enforceable. So read it and pay attention to it. Non-competes have their problems, though. There are other ways you can protect what you're doing. You can do it with things called non-solicitation clauses. That is, you can leave and work for whoever you want to work for, but you can't call on my clients and you can't call on your colleagues who used to work with you. There's no, except for being completely unreasonable, there's no legal limits to that. If you see those, they are enforceable, or if you use them, they're enforceable. And finally, let's talk about non-disclosure agreements. The whole idea of a non-disclosure agreement, I think in a lot of ways, the most powerful form of intellectual property protection is trade secret protection. It's just like we keep it a secret. We don't tell people unless we're in a confidential relationship. It doesn't need to be patentable and meet those requirements. It doesn't need to be copyrightable. It doesn't need to be capable of being a trademark. It's just something I know that I don't want the public to know. That works. It's very powerful protection. But here's the key thing to remember. Every time you share that piece of information, it has to be shared in a confidential relationship. That means with a non-disclosure agreement in place, or to like your lawyer or your accountant, where confidentiality is automatic. If one time you exchange that information without confidentiality in place, it's no longer confidential by definition. Here's why this is key for people like us. There are certainly VCs and private equity people in the world who say, I never sign NDAs. They're not worth anything. And, this is a matter of trust and we don't sign them. Okay. That's nice. That's a nice thing to say. It's bull. Okay? That's not how the law works. The way the law works is if I tell it one time outside of confidentiality, I cannot enforce the confidentiality of that piece of information against anyone. Not just against you, Mr. VC, who you want me to trust, and maybe I trust that you won't use my confidential information. But if that guy uses my confidential information and I didn't have an NDA in place with you, legally, that means it's not confidential anymore to anyone. So NDAs matter, use them every time. So let's move on to thing number 2, and really thing 2, 3, 4, and 5. I'm going to give you one truth and 2 lies about the business contracts you're in every day. All right, one truth is they are the law. Okay? When we're talking about a deal between one business and another business, whatever you wrote down and signed, that's the law of the deal. There are some limited ways in which, the law of the state, statutes, things courts do, might come into that relationship and say, oh, that's unreasonable, or we're not going to enforce it that way. But they're pretty few and far between. The main legal principle is a contract between 2 businesses is the law between 2 businesses. That means that what you write down really matters. It means you need to take the time and the effort to get that contract right because you're stuck with it. It means you may want to think about who's writing and reviewing your contracts because, again, you're stuck with it. It's the law. That's also something you can use to your advantage. All right? A lie you hear about contracts, you hear it less, but you still hear it some. Oh, it was a click to agree, right? It was like that, I'm clicking onto a website, it's license terms, whatever. I just clicked it. All I did was click it. They probably can't enforce that against me because I couldn't negotiate it. Whoever reads that stuff, but it doesn't matter. It can't be enforced. Oh, it's totally enforceable. It's completely enforceable. They're little limited ways around the edges that you might get out of some term in a click-through agreement. But by and large, it's just like any other contract. And the law has for a long time recognized click-through agreements, which also means, particularly for a lot of you in the software world and in the licensing world, that's to your advantage. Or I even have clients who are like home improvement contractors, right? And we put some of their contract online, and then their agreements, it says, don't forget to look at our terms and conditions online. That's largely enforceable. So it's a place you can hide a lot of terms that you don't necessarily want people to read, but you need them to protect you, right? That's been the game in licensing and in like software as a service for decades. Totally works, absolutely enforceable. You also hear, and this is a lie you hear a lot. You'll hear, you can't change anything in our contract. This is our standard agreement. No one ever changes anything in it. We use it for everybody. It's fine. You can just sign it because there's no point in having anybody review it. It's our standard agreement. We don't change it. That is complete bull. They do change it. I've seen them change it. They change them all the time. That is a bargaining technique usually used by larger organizations against smaller and entrepreneurial organizations, right? You are a supplier to big pharma. You are doing consulting work for a big company, and they say, this is our standard professional services agreement. We never change it. You have to use this one. No, you don't. I have found there is always a way to negotiate changes to those agreements because the fundamental thing is they want to do business with you. You're offering something that they want. You're at the table, you're having the conversation, you can make changes. Can you cover the thing in red ink and change everything? Of course you can. They do have, in some ways, greater bargaining power than you do. But if you pick your battles and you pick what's most important to you and you engage in some skilled negotiation, you can always change it. You can always make some changes. Sometimes you can make a lot of changes, and there are tricks to the trade for how to do that. But the key thing is That is a lie. It is a negotiating technique. That's all it is. Don't buy it. One more thing about contracts. Now, I lied. I'm going to give you one more thing. Here's a bonus truth. And the bonus truth is, let's dive deeper into what I just talked about. Because the reality that I've learned representing this kind of company is you actually have a negotiating advantage being an entrepreneur. And your negotiating advantage is literally who you are and what you do, right? Let's say, bigger company, it's come to you because of something unique you have, right? It's your product, it's your innovation, maybe it's your pricing, maybe it's a personal relationship, maybe it's responsiveness, but there is something there that got you to the table. They want it. You just need to use that to your advantage in negotiations. Let it give you some confidence that you can ask a question and push back on something. That doesn't mean they're immediately going to walk away from the table and go to somebody else. Does that happen occasionally? Yes, of course it does. You got to read every negotiating situation. But usually you're fine asking some questions. And you want to keep reminding the business side of the people you're dealing with why they came to you in the first place. So one of the things I will say is use your value and your values as negotiating advantages. Your value in that thing you offer that's different than other people offer. Your values in that I find it even works to say things like, yeah, I get it. This works when you're doing, when some other big company is your supplier, but that's just not practical for me, right? You came to me, you wanted what I have, and this term here, there's no way I can match that on a cash flow basis, let's say, right? Right. I understand you want $10 million of cyber coverage for all of your vendors, but that doesn't really fit for us, right? And the whole reason you want to do work with us is for the nature of our business, which is why that doesn't fit into our business model. We got to change that term. 8 times out of 10, that works. So use your own self to your advantage. Let's talk about worker classification, completely flipping the switch here to things like you are an employee or a worker, or you have employees or workers. This is an enormous issue. It is a big old landmine waiting for small companies. And the landmine has to do with the difference between employees and independent contractors. People that you pay a salary and they get a W-2 at the end of the year, and people that you pay just a fee to and they get a 1099 at the end of the year. Everyone thinks they know the difference between those two. And 95% of the people who think that are wrong. This is a fairly complex area. It's a thorny area, and most of all, it's not intuitive. It's especially not intuitive in New Jersey. So let me use New Jersey as an example, since we're all sitting in New Jersey. Right? The New Jersey Department of Labor has its own set of rules to determine who should properly be treated as an employee and who can be treated as an independent contractor. Companies love independent contractors because I don't have the same commitment to you as I would to an employee. I can get rid of you more easily. I don't have to do withholding taxes. I don't have to pay my share of unemployment insurance. Right? I may not need workers' compensation insurance. So much cheaper and easier if you're an independent contractor, which is why so many companies bring everybody in as an independent contractor. But the state of New Jersey says very few people correctly fit in that category of independent contractors. And if the Department of Labor audits your business and determines you had people who should have been, they think, employees instead of independent contractors, they will hit you for fines, back taxes. It's expensive. It's very thorny. So you want to get this right. And the key thing is, it is not intuitive. It's not what you think. You have to really dig in. New Jersey is actually at the moment in the middle of potentially changing its rules, although the main change is to say there's a way the Department of Labor has been interpreting, and we're going to actually codify that and make it hard law. That's kind of stalled. It was expected to happen like over the summer, and it didn't. And I'm not seeing a lot of talk about it the last couple months, but it's still there, and it could still come back. And the main thing is, well, these are still the rules as the Department of Labor wants it to be. But let me give you a couple of examples. To be an independent contractor, if you 100% follow what the Department of Labor wants you to do, and there are twists and turns and exceptions. But if you read the letter of the rule, you have to meet the ABC test, 3 different things, and it's not A or B or C. It's to be an independent contractor, you have to be A, B, and C. Okay? One of those is, do you have a legitimate standalone business doing the thing you're doing as an independent contractor? So if I work full-time as a bookkeeper and I have a part-time gig being an audio engineer, the state would say, no, you should be a part-time employee when you're an audio engineer because you only have one client as an audio engineer. You don't have a standing business as an audio engineer. They would say you're not an independent contractor. You generally have to work somewhere other than at the place of business of the people who are paying you. You generally have to not do the thing that company is doing. So if it's an accounting firm and you're an accountant and they hire you to be an extra accountant, the state would say you can't be an independent contractor. So I could go on. The key lesson is it's not what you think, but getting it wrong is very expensive. So if you're using an independent contractor, or if you are an independent contractor, you want to dig into this. But I got to move on to number 7. Flip to a completely different topic. Your business charter. When I say your business charter, this is like the most boring early documents you deal with when you form a company. Your articles of formation or incorporation, your operating agreement if you have an LLC, your bylaws and shareholders agreement if you're a company, if you're a corporation, your partnership agreement if you actually are a partnership or a limited partnership, right? Those documents matter a lot, and they matter in ways that it's really hard to see especially when you first start up. It's really hard to appreciate how they're going to count. Why do they count? The example I can give you is the bus. What about the bus? Okay, think about the bus in 2 ways. One, there's the proverbial, what if I get hit by a bus? Okay, the charter, remember I said the contracts between people in business are the law? Okay, that charter is the law between you and the other people you're in business with, your investors, or the people you consider your partners, the people you started the company with. That's the law. It's how you make decisions. It's how you break up. It's how you grow. It's how you deal with tough times. And it's also how you deal with when you got hit by a bus. Now what happens to the company? That's in that charter. The other way that I think about the bus is, what if I get thrown under it, or I want to throw somebody else under it? So let's say the 3 of us have been running the company and we all started a company and we decide that Joe here, we're throwing him under the bus. He's got to go, or he's the one who did something wrong. Can you do that? Can you get rid of the Joes when you need to get rid of the Joes? If you are the Joe, can they get rid of you? And I will say I had a client with a very nice software startup cooking along. He gotten into a dispute with somebody who was really his deputy, but the documents weren't very good, the documents that they signed before they hired me. And then they never really wanted to get around to changing it because they were busy running the business. And then they had a fight, and he couldn't actually get rid of this guy, and they just had to close the company. Like, perfectly good company shut down because its constitution was bad, basically. Because it didn't give the people who needed freedom of power and freedom of movement that freedom of movement. So your business charter matters. Okay, we're up to number 8. What about AI? You can't talk about anything now without talking about AI. I'm on LinkedIn all the time. And it's like every day, there's like 18 things. It's like, oh, you don't need your lawyer, use AI. And if you're a lawyer, you should do this. And it's like, it's going to, this is one of the professions that AI is going to replace, yada, 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 right? Can AI actually replace your lawyer? And for this, let me turn for expertise and for a contrast. This is the New Zealand-based indie band, The Beths, whose previous album contained what I believe to be the best song of 2022. And a question I ask myself when I look at all this chatter about AI. The title track of that album was, or a lyric from that title track is, am I an expert in a dying field? It was actually the title of the album, Expert in a Dying Field. If you haven't heard it, you need to get the album. It's really great. Right? Am I an expert in a dying field? Or, to turn to the lead track of the Beth's new album, is the straight line that we all want to see in AI, is a straight line a lie? And the answer is the straight line is a lie. Here's what I mean. Let's remember what large language models and generative AI are really, really good at doing is sounding right, right? The whole idea of LLMs is predictive, right? We can, the machine can predict what the next word should be and what would sound right and what comes out right. That's what it's great at. So when I have clients who say to ChatGPT or Gemini or whatever, write me a contract, and they read the contract, it sounds right. Of course it sounds right. Gen I's great at making it sound right, but it's wrong. Like, I've tried it. I've seen what my clients have shown me. The output is still wrong. The output is still legally wrong. I myself use AI tools. I'm trying to find new AI tools all the time. It's part of my job and the practice I have and the clients I have to constantly drive to be more efficient, right? How can I be more efficient what I do so I keep my rates down, so I keep the time it takes me to do things down, save my clients money? That's my job, right? So I'm trying the tools out too. I'm trying the tools that are dedicated tools for lawyers. I'll ask those tools a legal question, get one answer. I ask the question again, I get a different answer. I'll ask those tools, take this contract, tell me, does it conform with all these requirements? Because the tool says that's what it can do. I'll give you the example. Does this contract meet all the requirements of New Jersey's Home Improvement Act? Oh, yes, it has these 3 things that the Act requires. That's true, but it's missing these 3 other things that the Act requires. So, in fact, the contract is not compliant. Absolutely flat out wrong legal answer. The AI is going to get better. I have a good friend who's an AI. He offers 2 things that I think are both true, right? One is the AI we're using now is the worst AI any of us will ever use. Good point, right? And the other is the AI is the mean of the internet. I don't know about you, but when I make a deal and that deal is the law, I want that deal to be better than average. I want it to be better than the average of what the internet turns out. I want it to fit my deal and get me a good deal, and to know I'm not going to get screwed at the end of the deal. AI is not there yet, and it's especially not there if you use it for yourself without a lawyer. And the final example I'll give you is I've had clients who've come to me and said, hey, I had ChatGPT draft this out. Can you just take a look with it? Tell me if it's okay and maybe tweak it if things are wrong? And my answer to that is, yeah, I can do that. Absolutely can look at it and I'll tweak it and I'll make sure it's got everything it needs. That'll take me, I don't know, a couple hours. Or I can start with the template my firm uses that I have massaged for years for this kind of business situation and make it fit your deal, and that'll take me half an hour. What would you rather I do? Obviously, you'd rather I did the thing that was faster, and the faster thing is not to use AI. So we are not yet at the point that you can use AI instead of using your lawyer. We are at a point where lawyers need to keep experimenting with it. So the 9th legalish thing all of you should know follows from this, which is talk to a professional when you get into these professional things. I mean, part of it is the practice of law, for example, has a lot of subtleties to it. It's an art as well as a science. There's negotiating strategies. There's what you see and experience. Like AI just does not have that subtlety. It doesn't have that experience. It isn't nuanced in that way yet. And that's just one object lesson. Talk to somebody else who's a business lawyer if you want. I'm not the only game in town. But you do want to talk to a pro on these things because, as I said, it's the law. It is what determines whether your deal is successful, whether you get what you want, whether your business keeps going. It's worth the time and effort. That was 9 legalish things that you all should know. Hey, it's been fun. Hope you found it useful. And I'll leave you with my entrepreneur's motto. To me, this is the core of entrepreneurship. This sucks. How do I make money from it? Good luck finding those things that suck for other people and making money with it.